Your Honor, at this time, we are just asking, there is an emergency guardianship that has been in place since that initial hearing. Lillian continues to reside with Grandma, Miss Arnett, and we are just asking that the court support the full guardianship until the child has graduated from high school, which will be 1 year from now, or less than a year from now. She's entering her senior year. To my knowledge, I haven't received any formal objections to the petition. So again, the circumstances that were in place when the petition was filed still stay, and we are asking that parenting time be as Lillian agrees or wishes to see her mom. And then we are also asking that some type of support also be ordered in this case.
All right, Deputy Ames, would you swear in Ms. Freeze and actually the rest of our parties as well?
Remain seated, but raise your right hands, please. Thank you. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? And please give me a verbal answer.
I do.
I do. All right, Ms. Freeze, I have your report. Would you like to confirm that on record and then add any comments you might have?
Yeah, so I completed a investigation with Mrs. Arnett. And I do want to put it on the record. My report says her daughter Rachel, but it's Michelle. I don't know. So I apologize, but I did spell her name wrong. But I did complete a home visit. The home is appropriate. I spoke with Lillian. I mean, she wants to stay with her grandma, so I am in support. Everyone's appropriate. We ran clearances, CPS history, everything came back clear. So I am recommending that she stay with her grandmother.
Thank you.
You're welcome.
Okay, Ms. Jesusa Arnett, do you have any comments today?
I do not, Your Honor.
Right. Ms. Ashley Winans, do you have any objection to the request for guardianship?
So I had actually spoken to Jesus's attorney and said that I would be wanting to come to some sort of agreement with this. And she had told me that they were going to try to arrange a conference call with me to discuss this beforehand, and I never heard back from her. But I do have some concerns. I'm not objecting to Jesusa having guardianship of my daughter. You know, I made the choice that my daughter could live with her grandma, and I had no intentions of changing that. But I would like to be able to participate in major medical decisions for my daughter. I also would like my daughter to have to participate in counseling. There was an agreement between everyone who's involved with my daughter's life, her grandma, her aunt, her uncle, her dad's girlfriend or ex-girlfriend, that and my daughter, that she would start therapy because she really, really desperately needs it. And therapy was arranged, and my Jesusa did not send my daughter to therapy. And so I'm very concerned about that. My daughter was very excited for a couple weeks before going to therapy. I talked to her several times. She was very open to starting therapy. And then the day of her appointment, I received messages from both Jesusa and my daughter that she was not going to be attending her therapy appointment. So that's one of my major concerns. And just that I want to be able to participate in major medical decisions for my daughter. Jesusa, I feel, especially with this therapy situation, has not made the best choices for the medical, making medical appointments, her not taking my daughter, making eye appointments. They didn't show up for the eye appointment. So I'm just very concerned that my daughter is not going to receive all of the medical care that she needs. And then lastly, I'm also concerned, Jesus, my daughter gets survivor benefits through her father's passing away. And I don't think that Jesusa has made the best financial decisions with my daughter's money. And I'm also concerned about that. So In fact, my daughter's money paid for her attorney for this hearing. And I don't think that's appropriate that she's using, I'm sure, thousands of dollars to retain an attorney to come to court, especially when she didn't ask me, hey, I need guardianship of Lily. I want to be able to make medical decisions for her. I want to be able to do this, do that. So here, and I reached out to her attorney. I told her I was more than willing to come to an agreement. I didn't want to have to come to a hearing. And so here we are using thousands of dollars of my daughter's money to pay for an attorney to be here today. And I don't think that that's appropriate. I think that she should have to pay my daughter back.
Ms. Lillian Arnett, do you wish to have Jesusa Arnett in the role actively of parent? And that would include you staying where you are, obviously, but it would continue to allow Jesusa Arnett to have control over where you are, what your medical care is, what happens with those funds, all of those things. Do you understand that? Is that what you wish to do? Well, I would be inclined to send all parties to mediation, and the court can facilitate the cost of that on some of the issues that were raised by Ms. Winans, as well as the issue potentially of support to consider that benefit as well, and parenting time for purposes of producing a placement plan. So do you have any objection to that, Ms. Underwood?
With respect to,
I'll make a ruling on the guardianship today. I'll give you an opportunity to ask any questions of any other witnesses. And then if I grant the guardianship, which it does sound like for the most part, Ms. Winans doesn't have any objections, nor has she contested the factual basis of the petition. But there are some issues that could be worked out, in my opinion, on mediation.
I'm sorry, I just
Ms.
want
Winans, I can't allow you to interrupt.
I'm sorry.
So that's what I'm thinking, but I'm happy to listen to any further witness testimony or whatever else you might want to present.
my client would like to leave.
I'd like to respond.
I mean, I can call my client. Again, I'm not sure. Again, there was talks of having a meeting with Ms. Winans. However, after speaking with my client, I don't know that there would have been any productivity that would have occurred there. And because she was not necessarily opposed to Lillian staying where she is, again, I felt it would be best to just have a ruling on the guardianship. As far as support and other issues regarding medical care, again, if there's a court order that says, Your Honor, that Jesusa is responsible for setting up and participating in medical appointments for the child, she'll do so. Lillian's also 17, so she's capable of getting herself to appointments, and she's at the age of she's able to participate in those. Typically with guardianships, again, I know there isn't always a child support component, so whether that can just be remanded to the appropriate friend of the court or wherever that would go for support, I would be in agreement with that. I just am not sure how productive a mediation would be in these circumstances, because Ms. Arnett and Ms. Winans do not see eye to eye really at all. But Ms. Winans does at least trust my client enough to be able to put her child in Ms. Arnett's care while she lives in another county. So at this point, I think the most productive or expedient matter would probably be for you to make your ruling on the guardianship, and then whatever the traditional or standard way to determine support would be my recommendation or my position on that.
Ms. Winans, did you wish to say anything else?
Yes, please. So, with all of that being said, it's not necessarily that I trust Jesusa. It's that I made the decision to allow my daughter to stay there because I was moving. She really wanted to stay in Lenawee County because she wanted to continue to attend school there. She didn't want to leave all of her friends. We've had quite a few issues with attendance since she's been with Jesusa. with her skipping school, Jesusa was aware that she was skipping school.
So Ms. Winans, here's the bottom line for me today. I need to know whether or not you are objecting to the request for guardianship.
So-
All of the rest of this, I'm gonna send all of you to mediation on, and whatever you can't agree on, then you're gonna come back to me and I'm gonna make those decisions. But for purposes of the issue Ms. Underwood raised and the issues that you are raising, those need to be considered in the context of the placement plan. So the placement plan identifies why the child is in the guardianship, what the barriers are between, as far as reuniting the child and the parent, and visitation and support. And all of you need to sit down in a context outside of this courtroom and air those issues in an organized, civilized manner, which mediation will afford you the opportunity to do that. If an agreement cannot be reached on some of those things, then I would expect you to come back and I'll make a ruling on what the issues are, on what the visitation is going to be, and on any support. Enforcement is done on a civil basis, unless there are, sometimes the prosecutor's office is triggered to pursue that because benefits have been requested from the state of Michigan. But as it relates to guardianship, the front of the court typically does not get involved with support. That will, however, be something that our mediator will be able to discuss and allow you to discuss, especially considering that there are benefits already in place.
Is it,
So it sounds to me
possible to
like
do
you have made
partial?
Ms. Winans, I haven't heard anything that would indicate to me that you intend to take your daughter back into your care. Is that the case?
Not necessarily, I'm asking, is it possible to do guardianship where she has partial guardianship and I also have guardianship? Because I don't think that this is a situation where it's appropriate for her to have the only rights to make medical decisions for my daughter. That's not appropriate.
At this juncture, the request made of the court is to consider a full guardianship, not a limited guardianship. A limited guardianship would be one where you are consenting to.
Then yes, I object.
All right. Any further presentation, Ms. Underwood, on the underlying request? No, you're on. Very good. All right, the court finds all interested parties were given notice for purposes of today's hearing on guardianship. I reviewed the file. I was present for the initial hearing wherein it was necessary to grant emergency guardianship power to Ms. Jesusa Arnett for Lillian in order to allow her to get medical care, enroll in school, and all of those issues that she needed Jesusa Arnett to tackle because she was not living with a parent at the time. She was in fact living with Ms. Jesusa Arnett when the petition was filed. She continues to reside with Jesusa Arnett at the time of this hearing on the request for full guardianship. And I do hear and honor the mother's objections on these issues. However, at the end of the day, I have to simply evaluate whether or not the components of the statute have been met. And in this case, I do find they have been met. I have a situation where unfortunately Lillian's father has passed away and her mother has allowed her to reside with Jesusa Arnett without providing her the legal authority for the care and maintenance of the child. And she was not residing with the parent when the petition was filed, as I've already articulated. I find further, as a result of what I've heard, my familiarity with the file, as well as the investigation conducted by the department, that the welfare of Lillian Rosa Arnett is served by the appointment of this guardianship. I hear your concerns, Ms. Winans, and that is why I am sending the case to mediation for purposes of the placement plan. I know customarily, not every court requires a placement plan in full guardianships, but I do. That is so that in the event that mom comes back and wants this child back into her care, I have a plan to look at whether or not she's succeeded in visiting when she said she was going to visit, in participating as she says she wants to participate. I want to look at what that plan is. And that way, if there's a request for termination of guardianship in the future, I can make an informed decision on what the plan was and whether or not it was followed. Will be the order of the court. The petition is granted. Jesusa Arnett is appointed the full guardian of Lillian. It is a regular appointment requiring annual reports. And again, the parties will be sent to mediation regarding period of time, child support, and the rest of the components of the placement plan. But as of today, I am granting the request to allow Lisa Arnett to serve as guardian for Lillian because as I see it, that's necessary under the circumstances, for the reasons that I mentioned. The court will submit to you, Ms. Winans, the information to contact the mediator. We are going to pay him. We have a certain amount of funds set aside in order to do that, but you will be required to cooperate with mediation. And I think they can maybe do that by Zoom, but I'll leave that to you and the mediator to organize. And I wish you the best of luck. That's all for today.
Will I receive that from the court or will that be coming from her attorney?
That will be coming from the court. The information on the mediation will be coming from the court. Are you still, let's see. I think, have you received mail from the court, notices and all that?
So everything has come from Jesus's attorney. And except for a note, I never received a notice for the emergency hearing. My daughter was told that the attorney emailed me. I never received an email from the attorney. I searched both of my emails. So I just want to
Okay,
make.
I'm gonna, Ms. Winans, all I need to know is if your address is correct, so I'm gonna